The hot coffee case. In 1992, a 79-year-old woman named Stella Liebeck was severely burned by a coffee from McDonald's that fell in her lap. This caused her to suffer third-degree burns and be hospitalized for 8 days. It took her 2 years to recover. In 1994, Liebeck sued McDonald's to cover her medical expenses, offering to settle the case for $20,000. However, McDonald's would only offer her $800. While this case is often considered the most frivolous, ironically, it did have some legal merit. The coffee served at McDonald's was found to be 30 to 40 degrees hotter than coffee served by other companies, and 700 other people had been burned before. While coffee from these other companies can also cause third-degree burns, it would take much longer to do so, while the coffee from McDonald's could cause burns in just a few seconds. McDonald's didn't see the 700 as significant enough with the billions of cups of coffee served annually. When the case went to court, jurors awarded Liebeck with significant damages which were later reduced. The Michael Jordan Lookalike. In 2006, a man named Alan Heckert sued famous basketball player Michael Jordan and athletic company Nike for a total of $832 million. Heckert claimed that people would constantly approach him and tell him that he resembled Jordan. This caused him emotional distress and suffering, and he wanted to be recognized as himself rather than Jordan, and sued Jordan and Nike as the latter helped to make Jordan famous. Heckert dropped the lawsuit later in the year. The Pants Lawsuit. In 2005, a Washington, D.C. judge named Roy Pearson sued his local dry cleaners after the establishment allegedly lost his pants. The amount he sued for was $54 million for inconvenience and mental distress. This was also based on how he claimed that a sign on the window of the dry cleaners, which said "Satisfaction Guaranteed," was misleading. The case went to trial in 2007, with Pearson losing the case. Despite winning the case, the owners of the dry cleaners lost money due to attorney fees and decreased business, and despite earning money from fundraising to cover the costs, the owners closed and sold the shop due to lack of revenue and the emotional strain of the lawsuit. The beer commercial case. In 1991, a man named Richard Overton filed a lawsuit against Brewing Company Anheuser-Busch for $10,000, citing false advertising which allegedly caused emotional distress. This was based on how the company's commercials misled him to believe that drinking their beer would magically lead him to encounters with attractive women and happy settings. The case was quickly dismissed, as the beer advertisements were meant to be exaggerated and used for entertainment. Inmate sues himself. In 1995, a prison inmate in Virginia named Robert Lee Brock filed a $5 million lawsuit against himself. He wrote that in 1993, when he was drinking alcohol, he caused himself to violate his religious beliefs and get arrested. He wanted to pay himself $5 million. Since he didn't have income in prison, he asked the state to pay it. The judge dismissed the lawsuit, stating that Brock's claim was, quote-unquote, totally ludicrous. Psychic versus surgeon. In 1976, a woman named Judith Richardson Hames went to a hospital for a computed axial tomography, or CAT scan, to find out the cause of tumors in her ear. Before this, she earned a living as a psychic, reading auras and helping solve crimes. While at the hospital, Hames warned the radiologist that she previously had allergic reactions to iodine-based dyes. The radiologist dismissed this warning and decided to experiment with a small amount of dye. When this dye was injected into Hames, she went into shock and suffered from severe symptoms for days, including intense headaches. These headaches deeply affected her mental concentration and she had to close down her psychic business. She sued the hospital for malpractice and a jury awarded her $988,000. However, the judge denied this as excessive and agreed on an appeal, ordering a new trial. In the second trial, the case was dismissed as the judge ruled that Hames's medical expert lacked qualifications. Jelly Belly Candy. In 2017, a woman named Jessica Gomez filed a federal class action lawsuit against Jelly Belly Candy Company, claiming that they mislabeled the sugar on the list of ingredients for the Sport Beans product, and she was duped into buying what she thought was a performance-enhancing snack. The lawsuit said that the company advertises its Sport Beans as a sports performance aid that provides energy, listing evaporated cane juice instead of sugar to make it seem less like candy and better for athletes. Gomez's attorneys wrote this as deceptive. Company attorneys argued that the sugar content is clearly shown on the nutrition facts label on the package, and it wasn't trying to deceive consumers about it. They also argued that Gomez didn't indicate if she even ate a sport bean and why the cane juice mattered to her. The case was dismissed. The Subway Footlong case. In 2016, customers sued fast food chain Subway for selling footlong sandwiches that were allegedly less than the advertised 12 inches. Subway agreed to settle the case for $525,000, most of which went to the customers' lawyers. This amount was seen as cheap with all the media attention the lawsuit got. Subway also agreed to additional disclosures to customers. The court viewed this case as trivial, as only few buyers really cared if they got sandwiches less than 12 inches, and it would be hard to find these buyers, since the lawsuit was filed as a class action lawsuit instead of an individual one. Even then, it was tested that customers who got shorted would get the same nutritional and caloric value as if they got full-length sandwiches. Crunch Berries. In 2009, a woman sued the makers of the cereal Cap'n Crunch for $5 million after claiming to have been misled about the nutritional message of the Crunch Berries cereal. She claimed the cereal's marketing and packaging made it seem like the cereal was real fruit. The judge dismissed the lawsuit, stating that no reasonable person would conclude that the cereal was actual fruit. Impossible Whopper. In 2019, a vegan man sued Burger King for allegedly misleading vegetarian customers by cooking the Impossible Whopper, a plant-based burger, on the same stove as meat patties, contaminating it with meat. The man saw this as deceptive and unlawful conduct and issued the complaint. Burger King didn't specifically label the Impossible Whopper as vegan or vegetarian, since the restaurants have an open kitchen environment and contact with meat is likely. More plaintiffs came forward, and a judge dismissed the lawsuit as these plaintiffs did not ask about the cooking method and there was not enough evidence that consumers would be fooled about whether the plant-based burger would be cooked separately from meat products. Starbucks Iced Coffee. In 2016, a class action lawsuit was filed against coffee chain Starbucks for filling drinks with too much ice. The judge dismissed the lawsuit, concluding that any typical customer would not feel cheated by ice cubes. The judge also put forward a simple solution: order cold drinks without ice. Similar accusations were made by a woman in Illinois who said that Starbucks used too much ice. Another case involved two plaintiffs who charged that lattes were being served with too much foam, with this case being allowed to proceed as Starbucks was consistently adding too much foam. Velveeta Mac and Cheese. In 2023, a woman filed a $5 million lawsuit against food company Kraft Heinz for allegedly misleading consumers by promising that it only takes 3.5 minutes to prepare a cup of the company's microwavable Velveeta macaroni and cheese. The woman stated that the listed time, which was only meant for how long it should be microwaved, should have included the time to remove the lid, add water, and stir in cheese sauce. A federal judge dismissed the lawsuit as the woman lacked standing, as she never alleged that she was not able to eat nor had even tried to cook the mac and cheese she bought. The judge also believed that the woman now knows that the 3.5 minutes was only for microwaving the cup. Russia fines Google. Recently this year, a court in Russia ordered tech giant Google to pay a fine after the latter allegedly barred pro-Moscow propaganda channels on YouTube. This fine's amount? $20.5 decillion. This would be written as 20 followed by 33 zeros. This is far more than Google's $2 trillion value, as well as more than the entire world's wealth. As of recently, Google appeared unfazed by these demands, believing that there will be no negative effect of this lawsuit. Thanks for watching.